Thanks for being with us today. My name is Karl Butterer, and I'm going to be talking about some recent developments at the National Labor Relations Board and why those developments should get you thinking about revising some of your agreements with your employees. Specifically, you should be thinking about making changes to contracts that contain non-compete clauses, non-solicitation clauses, non-disparagement clauses, and confidentiality clauses. So the types of contracts that you would typically see those kinds of clauses in that you're going to want to revisit would include employment contracts, typically for sort of upper level employees, separation contracts, and severance contracts. When an employee leaves and you sign an agreement to govern the departure, you'll frequently see those kinds of clauses in those agreements. And then, of course, there's standalone non-competition agreements and standalone non-solicitation agreements. So let's start by talking about the National Labor Relations Board, the NLRB. Mike mentioned them earlier. I'm going to go into a little bit more depth just because it's important to understand how it functions and how the changes over there can affect you with regarding these contract clauses. So who are those folks over there, and what exactly do they do? Well, the NLRB is a federal agency which protects labor rights of private sector employees, again, private sector employees. And those employee labor rights are described in something called the National Labor Relations Act, or as we call it, the NLRA is how I'll refer to it throughout this presentation. And it's important to note that both union and non-union employees have rights under the NLRA. So even if you do not have a union present in your business, you must still pay attention to what the NLRA says and what the NLRB says about the NLRA related to your employees. So just because it sounds like a union-y labor type thing, it is that, but it also is going to apply to non-unionized employers. So it's important to note that the NLRA generally does not protect supervisors. And the term supervisor is defined in the NLRA. I'm not going to put the long definition up here for you, but you can contact me if you want it. Just very briefly, a supervisor is generally someone who has authority to exercise independent judgment over things like hiring and firing, promotion and discipline, or to effectively recommend such action. So if they have a particular influence, if the worker has the ability to say, look, I think we need to get rid of Joe, and that's given serious weight and Joe's fired, then that person who made that recommendation may be considered a supervisor. So I think you should probably just check with us if a particular person is a supervisor. But the takeaway here is if the employee is a supervisor, then the NLRA rules that I'm talking about here today, they're not going to apply to that worker. But these NLRA rules will certainly apply to non-supervisors. So what else does the NLRB do? It hears labor disputes and it acts as a judge on those disputes regarding the meaning interpretation of the NLRA. They can award remedies, which I have bolded here because we're going to talk about some changes regarding the remedies that the NLRB can award. And the NLRB's general counsel, that general counsel investigates and files charges, which are often called unfair labor practice charges that Mike mentioned earlier. It is the general counsel that investigates and files those charges for NLRA violations. And the general counsel issues memos on the interpretation of the NLRA. So those general counsel memos I think of as a weather vane. So what those memos do is it will tell you, for example, how the general counsel views a disputed issue under the NLRA. It tells us where the general counsel intends to focus her attention and the resources of the NLRB. These memos tell you what kinds of charges the general counsel is likely or unlikely to file against employers. Now, these memos, we have to footnote, these are not the same as a ruling by the NLRB. The NLRB issues decisions, so these memos are not rulings by the NLRB in and of themselves. Those NLRB rulings, by the way, can be appealed to federal Court of Appeals. And these memos are not the same as a federal court decision, but for the reasons I just explained, these memos are very important. It's the equivalent of a police officer saying, look, we're going to start pulling everybody over who goes 1 mile over the speed limit, where, you know, we're used to, everybody kind of knows you can go over 10 over and no one's going to get pulled over. Well, the general counsel, you know, like as enforcing the NLRA is going to say, look, this is how we're going to enforce in the future. So when the general counsel speaks in these memos, you know, employers really do need to listen. So let's get to the heart of the matter. There's been some recent action over at the NLRB, and that action is in May of 2023. The general counsel announced that most non-compete agreements violate the National Labor Relations Act. This is big, important news. And just as a reminder, a non-compete agreement typically prohibits a departing employee from engaging in a particular line of work or business. And typically we would see that limitation for over a geographic area where the employer does business for a period of time. But again, the non-compete restricts the employee from engaging in a particular line or work of business that their former employer or their employer, you know, engaged in. So what is general counsel's primary reasoning? I'm not going to go deep into this. It gets very legalistic, but this is a slide that you can look at. I'll be honest, I've tried pretty hard to understand this. It's not quite clicking for me, but let's go through the reasoning. These are the premises. If an employee exercises a right under the NLRA, for example, the right to organize a union, and an employer terminates that employee for exercising that right, and the employee is subject to a non-competition agreement, therefore, it's going to be harder for the employee to get a new job at the competitor that the agreement prohibits them from working for. And what that equals is that the non-competition agreement tends to chill the employee from exercising an NLRA right. This is what I see as the primary reason. There's some other explanations, but this is the heart of the matter as I see it. This is the reasoning. Whether you agree with it or not, this is how the general counsel is now thinking about these agreements. So this opinion that says most non-competes are unlawful, or rather an unfair labor practice, that applies to employers offering new agreements. So moving forward, it could be an unfair labor practice to offer a non-compete as part of an employment agreement or a severance agreement. Maintaining current agreements is also potential ULP, and enforcing past agreements. So if you have a former employee that you had a non-compete with, that you now find that employee is doing something that violates that non-compete agreement, and you now send them a nasty letter that says stop competing, that is an attempt to enforce a past agreement. And then, so that is considered, according to GC's opinion, an unfair labor practice. So now there are some exceptions to this general rule that non-compete agreements are unfair labor practices and unlawful under the NLRA. One exception is that an agreement may be lawful if it is narrowly tailored to special circumstances. But, frankly, I don't think the general counsel has ever seen a legitimate special circumstance. I mean, if you read her opinion, or her memo, she essentially says that there are these special circumstances and then describes how all the traditional special circumstances don't apply anymore. So I think you have to take that with a bit of a grain of salt. These are a couple interesting ones that it is lawful to have a non-compete agreement which clearly only restricts an individual's managerial interest in a competing business. And the general counsel also says it's lawful to have an agreement which clearly only restricts an individual's ownership in a competing business. So this is a very narrow area. The general counsel thinks you can still do. In other words, you have a departing employee, you can have a lawful non-compete that prevents them from having a managerial or ownership interest in a competitor. This is going to probably be the limited application, but I think it is, worth noting. So what about non-solicitation agreements? Let's remind ourselves what a non-solicitation is. It's different than a non-compete. A non-solicitation agreement typically prohibits a former employee from soliciting or inducing a customer to reduce business with a prior employer, or to solicit or induce an employee to quit and go to a new employer. So when it comes to customers, essentially an employee leaves employer, the non-solicitation would prevent that employee from going to a new employer and then calling on, for example, their old sales contacts at their former employer. So that's what a non-solicitation is. So I don't think there's much doubt going forward that non-solicitation of former employees is going to be enforced as being an unfair labor practice. But we did have some hope regarding non-solicitations that maybe the GC is not going to enforce these non-solicitations regarding solicitation of customers. And as recently as I think a week or two ago, I was in a conference room with Mike and Cliff, and we were sort of batting this back and forth. And I don't have much hope anymore that the general counsel is going to turn away from enforcing or trying to make these non-solicitations unlawful. We saw an original case that the charges were filed by the general counsel out of the Detroit office regarding a non-solicitation. It was a little bit ambiguous. There's a new case out of the Cincinnati regional office in which I think it's pretty unequivocal that the general counsel is going after non-solicitations of customers. I personally think the reasoning is weaker of the general counsel. That case is being litigated. That case could eventually, as I said, be appealed to a federal court, and maybe the general counsel may or may not prevail on this, but you should be aware of it. So we all need to stay tuned about that. So now what? Well, in my opinion, my advice is that you review your standard forum employment agreements. You review your standard non-competition agreements, your non-solicitation agreements, and your severance agreements. And again, these are for non-supervisor positions. I think you should consider redrafting your non-compete and your non-solicit clauses. I think I've lost control of there we go. I think you should consider not enforcing those clauses in the future. And I say consider because these are very fact-specific situations. I think it depends on how important these non-competes or non-solicitations are to you and your business. I think you have to evaluate what your appetite for risk is as to whether to try to enforce these or continue to use them, and just the particular circumstances of your business. But I think it's something that you should definitely be talking to your employment lawyers about. Now, there is one sort of silver lining that I see in this, or maybe at least one silver lining, and that is your former employers of your current employees may now be reluctant to enforce non-competes and non-solicitations against your employees. In other words, this is a double-edged sword. So if you have an employee that is chomping at the bit to go out and compete at your business against his former employer, well, that former employer is going to have to think pretty hard about whether they want to try to enforce that non-compete against your now employee. So, goose gander, double-edged sword, it's made these, rule or these opinions and some of these rulings may hurt you in some ways, but it may help you in other ways. I think that you should still write and enforce agreements to protect confidential business information. This is certainly still well within bounds, according even to the general counsel's opinion. Agreements to protect your trade secrets, and as I said, to restrict employees' future managerial or ownership interests in the competitor. Again, that's per the general counsel's opinion. So what other kinds of contract clauses violate the NLRA? I'm going to go over these briefly just so we flag them for you. One is that there's an NLRB decision that says overly broad confidentiality clauses in settlement agreements may violate the NLRA. You can keep financial terms secret, but overly broad confidentiality clauses. I think I saw that Cliff might be getting into this in a little bit more detail, so I will breeze by that. Overly broad non-disparagement clauses. So, when you have a settlement agreement and you basically, the employer says, okay, you don't say anything bad about us. Sometimes the employee will get a clause that says, okay, well, you're not going to say anything bad about me. If those are too broad, according to an NLRB decision, those are unfair labor practices. The general counsel has given us a little bit of a preview as to what else is on the table in terms of what she considers to be potential unfair labor practices that she will investigate and charge. And that includes no poach agreements between employers. There's some other laws that apply to no poach agreements. I'm strictly talking about National Labor Relations Act. She seems to think when two employers agree to not go after each other's employees, that violates the NLRA. The broad liability releases that go beyond the employer in your settlement and severance agreements, the GC has indicated that those may be unlawful. So when I write a severance agreement or a separation agreement, and I'm asking that the former employee release all claims, I try to get them to release everything possible under the sun against the employer, against individual employees, officers, the waterfront. And so they're very broad and they broadly protect the employer and their employees. Some of these releases that go beyond the employer themselves might be considered an unfair labor practice. Broad liability releases that go beyond the employment claims. So if you have a departing employee, you certainly want them to release any claims that they have against the employer that relate to their employment and the termination of employment. That's what you typically would see in a settlement agreement or a lease agreement. But sometimes we like to throw in the employee is releasing everything under the sun, not just employment claims, but everything and anything that they might be able to bring against the employer. The general counsel has weighed in and indicates that this might be on the table as to something she's going to go after. And then the cooperation requirements that you often see in these agreements essentially says, as employee, you're leaving, we're signing a severance agreement with you, but if there's any trouble over here with a federal agency or a lawsuit, you employee, you have to cooperate with us in defending those claims. This is something that you very typically see in settlement and severance agreements. But this is now potentially going to be challenged by the general counsel as well. So real quickly, I've got only about 30 seconds left on my time, so I'll blow through this kind of quickly, but there's this new case, Thriv, talks about what the remedies are that the NLRB can seek. Thriv says employers are subject to all direct or foreseeable damages flowing from NLRA violations. So all direct or foreseeable damages. That's a big, broad word, foreseeable. So that includes traditional, what we call make whole remedies that we're used to seeing, back pay, maybe reinstatement. But now these foreseeable damages include foreseeable consequential damages. So this has been, according to the general counsel, this can include, for example, a terminated employee if they have to go out of pocket for medical expenses because they lost their benefits. That's now a potential damage. Late credit card fees that they have to pay because they couldn't pay their credit card because of an unfair labor practice, rent payments, loss of a home or car. So it's getting broader and broader, and use your imagination as to what those foreseeable damages could be, because the NLRB will be. So that's it for me. I'm going to pass the baton now on to our next speaker, and naturally we welcome any questions.